committed about a month ago to come. So I brought my brothers here because Sister Sakina had made it clear that you guys were very enthusiastic about maybe even getting started with the process. So just in case I'm not able to handle an influx, I brought my brothers here to help me out, inshallah. Okay, can you hear me?
Yes,
sorry.
Lift up.
Lift it? Okay.
Yeah, that's
I'll hold this. Fine. Okay, let me sit down. So today, the Imam, alhamdulillah, he already covered the first part of the speech, so we can move towards the non-fiqh issues, because I'd like, inshallah, what we do, we write wills for all types of people. We write wills for Americans, we write wills for all in the day, we write wills for our brothers, the Shia brothers, our Sunni brothers, we write wills for everyone. So when it comes to the fiqh, we don't typically give, we ask them to work with us, and if they have special requests, to give them to us. And so we work with the masajid, and the fiqh part of it, the masajid tell us, and then we are able to incorporate that into Florida law. However, it is a very tricky thing, especially because if many of you guys have heard, there was a lot of times some things in the state legislature that were trying to say that any religious law or any law that is not the law of Florida should not be followed, right? So they tried to pass some laws like this. Alhamdulillah, all of them failed. It was about maybe 3-4 years ago where one almost passed, but alhamdulillah, it was after big opposition, it was taken away. But in anticipation of that, we as Muslim lawyers all over the country, we analyze the situation, and we really, there's ways that you can make your estate plan automatically become Islamic without having to get too much court involvement. Where that after you pass away, everything automatically goes where it should, or under a trustee who will actually incorporate your will without having to go in front of a judge. So that is the best way to do it. Otherwise, if you have to go to court and we don't know what's going to happen tomorrow or next year or whatever, and we have wills that say specific things that may be invalidated because of ignorance, we want to make sure that the wills that we write work today and work in the future also, inshallah. So let me talk a few things. My name is Abdurrahman Zeini, as the brothers mentioned. I've been doing this for about 11 years. My brother's here, Brother Siraj, he's been a lawyer since 2009, and he's from the Orlando area, but he moved back from Michigan recently. He was up in Michigan since what, 2009? 2009, and he came back to...
The warmth brought me back.
Yeah, the warmth brought him back to the Orlando, Florida area, alhamdulillah, and he joined me about 8 months ago, and Brother Zubair about a year ago joined me, and he's been a lawyer for about almost 3 years now, right? Yeah, alhamdulillah. So we practice mainly real estate law, business law, estate planning, and immigration. So wills and trusts, immigration, business, and real estate. But we have been doing a push for estate planning because recently we've seen a lot of really bad situations of people passing away and the families arguing, and a lot of things that are not good happening at the gravesite, after the gravesite, and then worse, families 2-3 years later still arguing about the mirath, which is not something that should even be argued about because it is written for us as Muslims. So this is Siraj Suhail and this is Zubair Dawood, and they work in association with us. So why do you need a will? If you don't have a will, what's going to happen is that there's a state law that says how things are going to pass to your heirs. And If the court can't find, if the state cannot find your heirs, or no one shows up to claim your inheritance, after 5 years, there's something called a sheet. It goes to the state. So it becomes property of the state of Florida automatically after 5 years. So having a will controls who inherits. And you as a human being in Florida, as a Florida citizen, have that right to choose who inherits. If you don't do anything, the state will control who inherits. But if you do write a will, what you write in that will is what would control. So as Muslims living in the West, it is imperative for us to keep that control while we have it, and not delay these things, because none of us know when we're going to pass. The next thing is that if you pass without a will, or even with a will that you didn't do correctly, you may just write it down and give it to someone. If you haven't followed the formalities, and believe it or not, the statutory formalities are very close to the Quranic formalities of a will. It actually, the state of Florida requires 2 witnesses in order for a will to be valid. And actually that's the only requirement. To make it more valid, if you have a notary as a third party, and all the witnesses and the person swear in front of a notary, that makes it easier to prove the will in court. However, only the 2 witnesses are required. And that matches the Islamic rule. We also have other options while you're doing your will. If you have a family member that needs special care, they get a share Islamically, but if you just leave it to them and you don't put it in the will, who should be their trustee? Who should be their guardian? If it is a child, who should be the guardian or the ward of the state? If you don't put that, the state will take that over as well. So it's very important to have all these things stated so that, again, you can control, and by you controlling, meaning you can put the Quranic and Islamic control over what happens after you pass away. And we all have this power while we're alive. We don't really have an excuse in front of Allah on the Day of Judgment that we didn't know, because now we know. And it's now that you know, it's become an obligation to at least act or try to act on it, because it leaves a big mess for the family. And we're going to discuss some recent things that we've been dealing with and are still dealing with. We have a case that's been dragging on. It's not even a difficult case.
It's not a difficult case, but she left. Yeah, what he's mentioning, I'll get to it, but the woman passed away. She didn't leave a will, and she had a couple of properties and this and that, just kind of getting everything together, finding family members. It became very complicated, but because there was no planning involved. She didn't think it through, and now it's very complicated, getting more expensive. We have to hire an attorney out of state to manage something. Another $4,000 or $5,000 are going to go over there for the legal fees. So it's just because of bad planning.
And in that same case, the brother doesn't even live here. He lives in Philadelphia. He's been in Florida since November, trying to deal with this, going to this bank, going to this thing, having to show them this document, having to do that, all because of bad planning, which could have been avoided with a document. So what are the goals? As I stated before, the main goal is to keep the case out of court. Because as soon as you start the court case, the minimum fee is going to cost you at least $4,000 or $5,000, your estate. So that's the money that you left your family. Even the easiest case will cost about $4,000 or $5,000. So that gets taken away from your estate.
That's best case scenario.
That's best. It's an easy case. Best case scenario. Okay. Probate is costly. There's a judge involved. You have to do, in Arabic it's ishar, but publication, that the person passed away and that you have to publish twice in a newspaper and wait, say, hey, does this person owe anyone any money? Does this person have any property anywhere? You have to do all these steps, and all these steps have waiting periods. And if someone shows up, this 4 or 5 months that this guy stayed, that's with no one showing up. If someone shows up and says, this person owes me money, how do you prove they don't owe them money, etc.? It becomes very complicated. So we want to avoid this thing that's called probate, which is going to court. If you only write a will, it will go to probate. Meaning you have to get the court to prove the will, and then you have to execute the will under court supervision. So a will, while it is recommended, that is like the basic, that's the minimum recommendation. That's like if you, let's say, if you're wearing clothes, for instance, minimum you have to cover a certain area, right? But that's not the recommendation if you're going to the masjid. That's not the recommendation if you're going outside in the cold, right? So a will is the minimum basic requirement to get your what you want to happen. However, you would still end up going to probate. The case would still have to go to a judge if you only have a will, which is why we're going to talk about what a trust is, and why we recommend that if you do have titled property, like real estate, like anything that's titled, real estate, bank accounts, 401ks, life insurance, those things, if your family situation is complicated, you should have a trust, so that it will make things easier for your heirs. Okay? And probate, like I said, is costly. Probate has to do with the value of what you left behind. And there is a minimum amount that a lawyer can charge for a case. And then that minimum amount is based on a percentage of your estate. So let's say your estate was $1 million. The minimum amount is what? 4% or 3%? 3%. So the lawyer, if you left a home and some land and a retirement account or something that you didn't put beneficiaries for, and that amount added up to $1 million, the lawyer is going to take $30,000 if it's an easy case. If it's a harder case, plus, and you know lawyers, we like to take your money. So leaving things to chance will cost your family headache, and it will take from their money, and a third party, the lawyers, the courts, and the creditors are going to take money. And go ahead.
I just want to chime in regarding the fee structure he's mentioning. There's not much leeway in that because the state and statute, they kind of lay out what they determine to be fair. So if it's statutorily written out, no lawyer is going to go below what the statute believes to be fair according to the Florida legislature. So that's, it's not something where you can negotiate down, because no one negotiates when the state says this is what's a fair amount of money.
Yes, exactly. And most lawyers are going to say, no, you're a Muslim, this is a complicated case by default, right? Because there's percentages and all this stuff. So it makes it not a simple case for a lawyer. Because with non-Muslims, a lot of times everything's just going to go to the spouse, or everything's just going to go to the children in equal shares. So it's again, leaving it to chance and going to probate is not a recommended action. Now, I don't have to continue saying this. The Imam, mashallah, he made a very good case, much better than I could do. It is an Islamic obligation. A lot of people come to our office, and as soon as we show them what the distribution is, Shaitan comes with them, and basically they hesitate. But
do you get the same experience when you talk about it? I know on our end, a lot of people, when we mention it, they sometimes feel hesitation or qualms. You feel the same on your end, and from the religious.
People come, yeah. People have these kinds of,
Yes. So people have concerns. However, just the last two words of this ayah, nasiban mafruda. It is a required, it's a fard, it's a mafrud, it's a share that is mafrud from there. No, not even from any faqih or anything. Nasiban mafruda from Allah subhanahu wa ta'ala.
That's why it's called ilm al-fara'id.
Yes. So there's no situation. Sometimes people are like, well, I have a special situation. I tell them, it's your will. You can do whatever you want in the will, in the dunya, and whatever you say is what's going to happen, but you're not answering to me. You don't have to convince me. I'll just write what you want. But if it was me, we're answering to Allah subhanahu wa ta'ala. This is not a joke. And then again, فَرِيضَةٌ مِّنَ اللَّهِ إِنَّ اللَّهَ كَانَ عَلِيمًا حَكِيمًا. Farida, safar, just like the prayer from Allah. Allah is all-knowing, all-wise. We're not wiser than Allah subhanahu wa ta'ala. Enough said about that. So we talked about the shares. This is the percentages between 1 million and 3 million is 2.5%. Between 3 and 5 million is 2%. This is the lawyer's fees, just the lawyer. Between 5 and 10 at 1.5%.
Above a certain amount.
Yeah, and then above 10 million, 1%. So if your estate, mashallah, is above $10 million, the lawyer will take $1 million. Straight up. That's if you allow it to go to probate. Okay? That's if you fail to plan. If you fail to plan, you're planning to what?
To fail.
To fail. So what is a living trust? This is how you avoid probate. One of you guys, my voice is a little bit.
And just wanted to kind of just swing back, if I could, real quick, just to kind of give a little bit of a example on one of the things is, we were talking about sometimes family members, you would want to do something Islamically and then, they change their mind. So I had a client recently, and we had a consultation. They said, okay, we want to do an Islamic will. And so I wanted everything done according to the Sharia and everything like that. So I said, alhamdulillah. So we drafted the will, we executed, we did everything. So she reviewed it, and I guess she showed it to one of her children at some point. And she called me back maybe a few days later afterwards. And she was like, what did you do for me? And I said, what? I was confused because I didn't know, I said, everything we had discussed, and that's what's in there. And her response was like, no, but why is the shares like this? Because we discussed that for the daughter and the son, there's a variance, right? The son gets twice what the daughter would get. And in this situation, she was like, no, this is not what I wanted. And you have these situations, and it's not far and few in between. It's very frequent. And she actually tore up the will. She literally tore it up. She said, no, I don't want this. And the fortunate thing is that she didn't have enough of an estate that it would really make a difference. But the idea that we're trying to drive home is that there's these things that we have to take into consideration. And what Abdurrahman and Siraj had also said is like, this is an obligation on us. Because if you think about it, this is our last deed going out. There's really nothing else we're going to do. Once we die, our deeds are cut. And this is one of those last things that we can have in place that we've done according to our religion. So that when we meet Allah subhanahu wa ta'ala, it's something that we've done and we know we've done it correctly. So I just wanted to give a little anecdote because this is something that is important, and there are unfortunately a lot of people that don't take it as seriously. And like Abdurrahman was saying, that Allah is the most wise. He knows what's good for us, and we don't know it sometimes ourselves. And so that's why we're talking about probably, there's different forms. And one was a will is good, and you can use a will in certain situations. A will may be best for the person, depending on their specific scenario. But if you have a multitude of assets, if it's something complex, we want to avoid the probate system. Because like Abdurrahman had said, is that we don't want to get into these situations where we're having to get more attorneys, more this, more that. It becomes more complex, and it costs the estate that we're going to have our beneficiaries paying out more money.
Yeah. Just one last thing. When I said the 1 million, that's how much the estate attorney can charge the estate, right? If there's a will contest, if one of the people, if you did your will wrong, and then one of the people's wives, sisters convinced her that she should overrule, there's something called elective share. and that she should try to overrule the case because you didn't sign a paper. If she gets her lawyer, she's gonna pay her lawyer also. The case will become even more complex, more money will come out of the estate, and then the other beneficiaries will all have to get their own lawyers too. And it becomes a big mess. And they were just saying, like, it was not a Muslim person, but Aretha Franklin, she passed away, she had so many millions of dollars, she didn't have a will. And her estate is having a serious problems right now.
Since we're doing anecdotes, I might as well add one more. This was I was going to say towards the end, but since we're talking about wills, I'm going to tell you a personal story, something that happened with my family, some relatives of mine. So I have family scattered throughout the world. Some family lives in the UK, and my family in the UK, he's kind of like I guess a grand uncle, if you will, or something to that effect. And so basically, you know, alhamdulillah, he had amassed some wealth from investments over time. And he had never created a will. And with his situation is he had a first wife, he had several children with the first wife, and they had, you know, there was some reasons and they got a divorce, and then he married a second wife. And with the second wife, he had one child. And so his health was deteriorating over time, but he never took the time to have a will set up and have a will done. And so towards the end of his life, his capacity, and that's one other thing we hadn't talked about also, is like with wills, there's also a time frame. You know, like how we have time frames for certain things. A will, you have to have capacity to make one. So you can't be incapacitated to make a will.
The Arabic word for it is aql. You know, baligh aql. You have to have, it's the same as the Islamic thing, you have to have mental capacity as well. You have to be above 18 and you have to have mental capacity.
Baligh aql.
Yes.
Same thing. And that's the thing. So his capacity wasn't there, it was waning. So he was going in and out, and my father-in-law, he was trying to talk to him and trying to see what he wanted to do. And they were going back and forth. And he was saying, because, you know, he wanted to take care of his first wife, he wanted certain things, and he also wanted to take care of something for his ex-wife. Now, he could have provided for that in a will, and he could have given her from a portion if he showed will. And because he didn't do so, there was a big fight. A huge fight, and he had several, from his first marriage, there were several children. I think there might have been 2 and 2, I'm not 100% sure. Off the top of my head, I can't remember correctly right now, but there might have been 2 sons and 2 daughters. And it was a fiasco, because they were all, all upset, and they all wanted, and sometimes, unfortunately, when it comes to money, things change. So in life, there may have never been an issue, because the money wasn't really in their face. It wasn't dangling in front of them, right? And even with the current spouse, like that's the thing in the U.S., especially in Florida, is like if you pass away and you have your spouse usually gets the vast majority of the share, depending on the children's situation, because it's always seemed as though that the mother's going to care for the children, etc., etc. So initially, they wanted to just like the families, they wanted to sort it out. Then the wife had to get advice.